Justice Jackson?
So I guess I'm not sure I understood your answer to Justice Barrett's question about the coextensive nature of aiding and abetting liability and the kind of liability we're talking about here, because I understood you to be rejecting material contribution, and I thought material contribution was a form of aiding and abetting liability. So maybe I'm confused. Are you rejecting the material contribution theory?
No, absolutely not, Your Honor. We embrace the full breadth of contributory liability that includes inducement and includes material contribution. And I gave Justice Kavanaugh a few examples
of how material contribution works in your
how it
view.
Would work in the ISP context. I'll hasten to add, though, the fact that there are not a lot of examples is a function of plaintiffs' decision to sue the one technology that is least likely to fit a fact pattern of material contribution.
That's only if you define it as being only Grokster or Sony. In other words, it depends on how you define material contribution, and I take your definition to be narrower than what I think respondents will say.
Oh, it's definitely narrower than what the respondents will say, because respondents have never purported to identify an affirmative act to foster infringement. Their argument is knowledge alone is what satisfies.
And your argument is knowledge plus providing the service, internet service, is not an affirmative act. Do I have that right?
That is correct. We are providing the internet service and declining to terminate. That's what we were held
to individual customers or ISP addresses, which makes it, some would say, different than Twitter, because Twitter was just, they were putting up a platform that people were using. But you've got contracts with individual people that you're providing internet service to, correct?
So contracts, yes, but there was an ongoing relationship in Twitter with all of the customers.
But I mean known in ways that you can isolate the ISP address and the places where the infringement is coming from.
We know the IP address. If it's a regional ISP, there are 10,000 possible homes or businesses who could be infringing. And as I was saying earlier, that's the first that will have to get cut off under this liability scheme.
All right, well, let me ask you, just in copyright law in general, my understanding is that Congress's goals are key. And I appreciate your view, and it's true that Congress hasn't provided statutory liability. But I do think, based on the statute that we have here, Congress understood that common law liability could arise. And so what concerns me a bit is your encouraging us to adopt a common law rule that would essentially eliminate liability in this situation. I guess I'm coming at this by looking, as several of my colleagues have pointed to, the safe harbor. Congress told us in the legislative history what the safe harbor was about. In one of the reports, the House report, Congress said that it wanted to, quote, preserve strong incentives for service providers and copyright owners to cooperate to detect and deal with copyright infringements. And so even though there isn't secondary liability in the statute, it appears as though Congress sought to use the liability risk that exists in the common law to incentivize this cooperation. And as several have pointed out, you seem to be undermining that because we no longer have the incentives if we interpreted this the way that you would have us do.
So two answers, Justice Jackson. The first is, just to continue the answer I was giving earlier, Congress had no clue what the liability would end up being against 4 different types of service providers. Back then, service providers were confronting all sorts of theories of liability. It included direct liability because you have to copy.
Right, but I'm positing that Congress's interest was not necessarily to protect ISPs. I appreciate that's in there, but what I'm pointing to is the part of the legislative history in which Congress said we are setting this up as an incentive for these ISPs to actually do things to address copyright infringement.
Right. So a couple of answers to that. First, I will get to the legislative history in a moment, but first and foremost, what Congress said was in 512L that the failure to satisfy a safe harbor, quote, shall not adversely bear on liability. And it punctuated this point in the Senate report. It was, quote, leaving current law in its evolving state because it had no idea and most certainly couldn't agree upon.
Correct. And the evolving state allowed for liability under certain circumstances. So if we now interpret this to not allow for liability, I'm a little worried we're undermining Congress's intent.
Your Honor, Congress had no idea what the liability would allow. There was no case at that point providing for liability for ISPs, that is holding them liable ultimately. I will also underscore there was no such thing as a conduit ISP. That was a creature of 512A. The AOLs of the world were hosting content. So Congress, one cannot impute to Congress any view, and certainly not any unified view, about what the liability rules would be in the absence of the DMCA.
Thank you.
Thank you, counsel.